John invited me many times to Mississippi, where he used to live. And I never made it down to Mississippi, but I'm more than excited to be here, not only at John's invitation, but because of Manchester's reputation in the field of international law. So I'm glad to be with you this afternoon, and I'd like to thank Professor Haskell for the invitation. So my talk today is about the narrow issue of World War II and the return of World War II, and the even narrower issue of corporate responsibility and corporate legal liability for the events of World War II. Just to get you guys started, I'd like to begin with this pair of images, and I'd just like to toss out to anybody in the crowd, can you tell me who these people are, right? So, who are these people? Anybody?
She's the president of the South Korea, the women.
Yeah.
And the middle one is the president of the Russia.
Mm-hmm.
And at the right, this is the chairman of the Republic of China.
Yes.
And the last one is the prime minister of the Japan.
Oh, Japan. Yeah. Okay. Good. So we know who the personnel are. And then does anybody else know what they are doing? This is actually both these photos were taken in the same month. So now that we know who they are, does anybody know what they are doing?
Just a guess. Where they started, like, sort of on the left picture, where they looking at the army marching thing in the celebration of the anniversary of the how many years?
70th.
Yeah.
Yeah, exactly right. So here, this is, it's as if they're looking down at us, and we are on Chang'an Street in Beijing, and we are a big military parade. And they are celebrating China's victory over Japan. That's how it's currently being talked about in 2015. And President Xi invited a number of world leaders, including David Cameron, including Barack Obama, including François Hollande, all of whom declined his invitation. President Putin showed up, as did President Park Geun-hye from South Korea. And over here, again, a picture a couple of weeks earlier of Prime Minister Abe Shinzo of Japan. And here, Prime Minister Abe is making an apology that took place on the 70th anniversary of World War II, expressing some amount of apology or regret for Japan's actions during World War II. Now, when he made that speech, I was in China, so I got the benefit of seeing how the Chinese media responded to it, and of course they thought it was insincere and rang hollow and wasn't sufficiently remorseful. And the South Korean media also said, well, he's just repeating what Koizumi Junichiro said 10 years before. There's not enough material here for us to consider this a sincere apology. But I begin with both of these images because I think it shows the importance and the contemporary relevance of World War II. This is something that I think most Americans, and I realize I'm not in front of most Americans, don't spend a lot of time thinking about. I think here in the UK, as I suspect in much of continental Europe, and certainly in East Asia, it is still very much an important historical marker. Right, so I'd like to begin this talk just by foregrounding how important World War II is, even now, some 74 years after the formal hostilities have ended. So let me talk sort of briefly about what I'm going to do over the next 30 or 35 minutes. I'm going to talk about some of the background research that informs this talk. I'll then look narrowly at this issue of World War II litigation as it has unfolded in Japan, as well as in South Korea. And then I'll make some conclusions about what all of this means. I'll also spend a couple of minutes talking about what I see as sort of some of the competing models that have arisen in the West, particularly what I'm going to call a transatlantic model. I'll define that term a little bit later, as well as a California model for handling some of these issues of war reparations. Right. So even if World War II ended formally in 1945. This issue of liability and the allocation of liability is still with us in 2019. And I should note that there are ongoing lawsuits right now in South Korea about World War II issues. Right? So even though none of us was alive in World War II, these issues of liability remain hotly debated and hotly contested in many parts of the world. Now you may be wondering, well, wait a minute, didn't we do this already? Didn't we have Nuremberg? Didn't we have Tokyo? Didn't we have a number of smaller national level commissions after the war to handle these issues? And we did, right? No one's denying that Nuremberg was not an important precedent, or the Tokyo tribunals, flawed as they were, are not important precedents, but they didn't handle everything. Right, they didn't handle all of the destruction, all of the war crimes, and all of the crimes against humanity, crimes against peace that unfolded during World War II. And indeed, a lot of what's been going on over the past 30 years has been to rectify, or at the very least to address some of those issues. So some of the things that haven't been talked about, some of the issues that are currently or have been recently litigated in the past 20 or so years, include things like comfort women, right, or military sexual slavery. This is something that was not talked about at all during the Tokyo Tribunal, and indeed hadn't really been talked about until the 1990s, the early 1990s, when Korean, then ultimately Chinese, and Taiwanese, and Filipina, and Indonesian comfort women came forward and said, yes, during World War II, we were essentially military sexual slaves to the Japanese army. Right? That part of history had been, if not erased, at least under erasure for quite some period. Japanese medical experimentation. Again, during the Tokyo tribunals, the US gained access to this information, and in exchange, the US said, okay, we won't prosecute some of your doctors if you hand over some of the information that you gleaned, all the information that you gleaned, that you, the Japanese military, gleaned by conducting medical experimentation on Chinese citizens. Right? So they would freeze their arms and then destroy them. They would infect them with anthrax. They would infect them with gonorrhea, and see what happens. Right? So that part of history had also been largely erased or forgotten. Chemical weapons, forced labor, slave labor, a number of these really important war crimes and crimes against humanity had been essentially undiscussed or unreflected upon for 50, 60 years. Right? It's not really until the 1990s, and I'll talk about this in my talk a little bit later, that these issues come forward and are actively litigated. And as I said, some of these are still being actively litigated even now. So when people talk about certainly the Tokyo Tribunal, there's this idea of victor's justice, that the Allies, specifically the United States, came and did their best to inspect Japanese war crimes or German war crimes, but insufficient attention was devoted to, say, American war crimes, right? For example, the bombing in Nagasaki or Hiroshima, which of course were war crimes and continue to be war crimes, were not obviously actively discussed in the Tokyo Tribunal. So, one thing we could think about, I use this term of white man's justice, meaning while Nuremberg and Tokyo tribunals are important precedents, they also contain blind spots, right? And those blind spots are only now in 2019 or in 2009 or in 1999 getting the kind of attention I think they deserve, right? So that helps understand part of what I'm doing here. A second sort of theme that I'm playing with here is this idea of corporate social responsibility and more narrowly corporate legal liability. Right? So for the past couple of decades, there have been a number of efforts from UN, from the OECD, from other international organizations to impose standards of governance and to impose basic human rights standards on multinational enterprises. I'm sure you guys have heard of the UN Global Compact. I'm sure some of you have heard of the OECD's regulations or guidelines for multinational corporations. These and other efforts ultimately led to what we call the Ruggie Principles, put together by John Ruggie at Harvard, to articulate what corporations should do and what kind of human rights obligations, if any, corporations owe to their employees as well as to the stakeholders in their community. In my personal opinion, the Ruggie Principles sort of don't go far enough in holding corporations to account. That's my own opinion. We can talk about whether they do or not, I suppose, in Q&A. But they don't sort of definitively say that corporations can incur legal liability when they commit human rights abuses, right? That's something I think many in the human rights community would have preferred. The principles go so far as to say, well, corporations have to respect human rights, but if there is a violation, it's still up to the national government or the national judiciary to provide that remedy. A second sort of theme about this issue of corporate legal liability has unfolded in the United States under the guise or under the context of the Alien Tort Statute. This is an old statute that the US passed in the late 18th century to deal with pirates. It was resurrected in the late 20th century, first to deal with government officials who had been engaged in human rights violations, and then, as is the case, once that sort of style or form of litigation proved to be successful, it was then applied to a number of multinational enterprises, right? So in the 1990s and the 2000s, and really up until this decade, you had a number of decisions that held out the possibility that corporations could be legally liable when they engage in human rights abuses, right? There have been a couple of recent decisions, Kiobel and Jesner from the US Supreme Court, that seem to have narrowed the applicability of the Alien Tort Statute to corporate conduct, but at least there was the possibility of this in some of these earlier decisions. A third kind of strand that I'm picking up on here is what US and other scholars have referred to as transnational Holocaust litigation. Right? So again, during the 1990s, you have a number of World War II era crimes being the subject of litigation here in Europe, particularly in Germany and Austria, and of course in the United States as well. So some of the claims that victims are bringing include things like bank accounts that had been essentially looted or taken over from Swiss banks, art that had been looted from people's personal collections. That's the Altman case, which involved a couple of Klimt paintings, and forced labor itself. Right, so a lot of people who had been either enslaved or reduced to forced labor during World War II stepped forward in the 1990s and said, "Oh, by the way, we're still waiting to get paid for those years of labor that we worked for German companies, or in one case, the German subsidiary of an American company called Ford Motor Company." Right. So again, American companies here are also caught up in the docket. Now, importantly, when people talk about THL or transnational Holocaust litigation, none of these cases actually succeeds on its own, right? There's no case where a federal judge or a German judge or an Austrian judge found in favor of the plaintiffs and said, yes, you were wronged, you never had your wages paid or what have you, and here I am ordering the corporation to pay you X amount of money. So we need to understand that the litigation not as a salvific device, but as a way of bringing attention to certain historical or in many cases long forgotten issues. But nevertheless, they were brought in federal court in the United States, and what we see is at least in these situations, a number of American officials, right? This is the case involving a guy named Stu Eisenstadt who worked in the Treasury Department. He, at the direction of then President Clinton, sort of took this issue up as his own, right? So he traveled to Germany, he traveled to Austria, he traveled to Switzerland, and was able to convince officials in those various states that they should set up funds, foundations, to pay a certain amount of compensation to forced laborers, or to have the art restored and returned to its rightful owners, or for insurance claims, or for bank accounts, or whatever it was. So you see, for example, I think probably the most famous example of this would be the German Remembrance Fund, something that's set up in 2000, half paid for by the German government, half paid for by German corporations. And this Remembrance Fund then made, again, relatively small, but I think nevertheless symbolically important payments to forced laborers and slave laborers, right? So if you were a slave laborer, meaning you worked in one of the Nazi death camps, you got paid $7,500. If you were a mere forced laborer working for a German company, then you got $2,500, right? So the important thing here isn't the amount of money, but that you had been recognized as a forced laborer, and that even though this is taking place, more than 50 years after the fact, there was still an attempt from a government to right the wrong, right? Importantly, though, at least in the German Remembrance Fund and the similar fund set up by the Swiss government, there was no apology, right? No, sorry, we did this to you, we apologize, and no admission of legal liability, right? So there was an admission of moral liability, what we did was wrong, but nowhere do you get the sense that either the corporation or the government that was complicit in enslaving these people had done something that was legally wrong, right? Enslaving people, of course, violates treaties, violates customary international law, violates domestic law, but none of that sort of made its way into the actual agreements, right? So this what I'm calling this transatlantic model sounds nice, right? And parts of it are nice, right? I think it is important, even if it's 55 years after the fact, to have official recognition of this and to have some small amount of compensation to accompany it. But it's not what I would consider to be a full compensation. When I go on to talk about some of the lawsuits in Japan, I'll have an opportunity to reflect on what it means to have a fuller sense of what reparation might look like. The other, I suppose, problem with this model is that it requires government officials who are willing to do this, right? I don't think you would have had a similar reaction from the Bush administration, right, which took office in 2001 to 2009. I can guarantee you would not have a particularly receptive audience if you were to bring this to the Trump administration. They would say, what? I mean, if they'd even let you in at all, right? So this model, I think, has some advantages, but it's highly dependent upon, to put it bluntly, having a Democrat in office in the United States, and also having willing interlocutors on this side of the Atlantic to say, yes, we know these legal claims are long past due or would be eliminated by any statute of limitations, but we still think they're important, right? So there's a significant amount of political will that such a scheme requires. I'll touch briefly on what I'm calling the California model. This was a law passed in the late 1990s, again, after some of this transnational Holocaust litigation had come forward. And what it did, it said, the statute of limitations for civil claims, depending on the country you're in, can be 3 years, 6 years, 10 years, 20 years, what have you. And this California law said, look, we're going to waive statutes of limitations, right? So here it is, 1999. If you can bring forward and have the factual basis to show that you had been enslaved, we will open up the state courts, right, not the federal courts, like the alien tort claims stuff I talked about. We'll open up the state courts of California to you and allow you to file suit in California state court, right? So that sounds all well and good. Again, the impetus was transnational Holocaust litigation, but soon after this law was passed, a number of Korean and Chinese and Taiwanese forced laborers were already in California because they had emigrated or came to California to file lawsuits against large Japanese corporations that had also used forced labor or slave labor during World War II. Ultimately, this law, put together by Tom Hyman's of the California legislature, is struck down. Basically, states in the United States don't have the capacity to engage in foreign relations, right? Only the federal government in DC has that capacity. So when states like California try to, what we call meddle in foreign affairs, that's our federal system is going to say, no, that's for us to do. States, you can do policing and education, but foreign affairs belongs to the federal government, right? So for that reason, this avenue of redress was shut down. Nevertheless, in removing this statute of limitations hurdle, it at least theoretically opened up the possibility of allowing redress for some of these very, very old legal claims. Okay, so that's my California model. Let me turn now to East Asia and talk about some of the events that took place there. Does anyone recognize this one? I'll be very surprised, but you never know. Okay, so this is a woman named Kim Hak Soo. For Chinese speakers, her name would be Jin Xue. And she was the first Korean woman to come forward and publicly acknowledge that she had been a comfort woman. Right? I mean, she was one of those people who had served Japanese soldiers during the war. Again, the experience of each individual comfort woman is quite distinct and different. Some of them would service 25, 30 soldiers a day. Some of them even more than that. And their existence, as you can imagine, was not a particularly happy one, right? So for decades after the war, there have been rumors of comfort women, but really until this woman stepped forward in 1991, no one, Japanese, Korean, Taiwanese, Indonesian, etc., had been willing to step forward and say, yes, I was actually one of these women who served in these comfort stations, right? Essentially, I don't want to call them brothels because that suggests that some of them were willing prostitutes, and that's one of the lines that conservative Japanese thinkers, including Abe himself, have used when describing the comfort women. It's like, oh, they were just prostitutes. I'm sure some of them had entered the system as prostitutes, but I think the vast majority of them were physically forced into doing this line of work. Nevertheless, she was the first person to sort of break the silence and to come forward and say she had actually served as a comfort woman. And several months after that, she actually made history again by suing the Japanese government, saying, look, what you did to me was a serious human rights violation, was a violation of other civil rights I had. And she sued the Japanese government together with some other comfort women, as well as other Korean victims from World War II, and so launched a transnational reparations movement that, as I said, continues to this day. In terms of what it looks like, there have been about 100 lawsuits filed in Japan. There have been about 25 lawsuits filed in Korea, a few lawsuits filed in China. Chinese courts have the blessing, I suppose, of deciding whether or not they want to accept jurisdiction, and they have generally said no. We do not want to accept jurisdiction for these. These are too politically sensitive. We're not going to allow these cases to move forward in China. Some of the, I said before, there have also been cases brought in the United States, not just for comfort women, for a whole range of World War II violations, right? So medical experimentation, the rape of Nanking, firebombing of Chongqing, and a couple dozen cases brought by forced laborers, right? That's where I'll turn in a minute. So with regards to corporate legal liability, to go back to that, a number of these lawsuits, roughly 25, were brought by Korean forced laborers and Chinese forced laborers against some of the largest corporations in the world. Household names like Mitsubishi and Mitsui and Sumitomo have all been defendants in these lawsuits, right? Brought from roughly 1991, as I said, up until the present. As I said, some of these cases are ongoing in Korea as we speak right now. Japanese courts, those that presided over these cases against Mitsui and so forth, have by and large dismissed these cases, saying, look, for a number of reasons, they are either too late, right? These are 70 years old, 60 years old, they come out, or they're long past due in terms of Japanese civil law and statute of limitations, or they have been handled through post-war treaties between Japan and South Korea, or between Japan and China. Right? So for either of these two reasons, we are going to dismiss this. Now, there have been a couple of cases where Japanese courts actually found in favor of the plaintiffs and said, yes, even though these cases were 60 years old or 50 years old, we have to apply the statute of limitations in good faith, and we see a good faith reason for tolling the statute of limitations and allowing you to move forward, right? So in a couple of cases, Japanese courts actually did award compensatory damages. The problem is that on appeal, those decisions were all overturned. And in Japan, the higher you get, the more conservative the court is, right? So if you get to the top, Supreme Court of Japan is the most conservative, and so in cases that got appealed to the Supreme Court of Japan, they were all overturned and rendered in favor of the defendants here, okay? Nevertheless, what I think is important about this is that, even when a Japanese court dismissed a case because it was time barred or dismissed it because it had been waived by a treaty, they actually articulate a number of different theories of liability, right? So again, if we're going to talk about having entertaining this idea of legal liability for corporations, one of the things we have to talk about is, okay, what are they going to be liable for, right? And unless we have court decisions that help us understand what that might look like, this theory of corporate legal liability will remain only a theory, and very rarely will it actually take shape as reality, right? So I won't go through any of these in detail, but I think it's important that we understand that on a number of occasions, right? So even if the court decides to dismiss the case as time barred or treaty barred, there are still theories that articulate, what precisely the conduct is that the corporation engaged in, and why it is tortious, or why it is something for which legal liability should attach. In one case, and again, I'm being selective here, just to give you a flavor for how these different theories have been articulated. One case, again, brought against Mitsubishi by a Korean person, said that even though Mitsubishi may have been liable for X, Y, and Z, what it in fact is liable for, what the court quite clearly found it liable for, was for false imprisonment. Essentially, these people Koreans were brought in to work in a mine or work in a factory and couldn't leave, right? And so the tort, as we would say, was to falsely imprison them. Say, no, you can't leave, you have to stay here and work for 12 hours a day. Or for the act of forced labor itself. Right, there was law, even in 1940 or 1942 or 1943 in Japan, that said what you can and can't do, and forcing someone to work was clearly a violation of Japanese domestic law. It was also, in case you're wondering, a violation of international law. And so, again, in this case and other cases like it, one of the theories of liability is sort of straightforward tort liability, false imprisonment, forced labor. The kind of thing that you might study here in your first year torts class. A second theory of liability is to impose upon the corporation an employer-employee-like relationship, right? So they would say, look, even if you didn't pay them a wage as an employer would, you are as if you corporation acted as if you were the employer, and so therefore, when in the employer-employee relationship, you have to abide by certain standards, right? You owe your charges, those whom you employ, a certain duty of care. And in this particular decision, and in others like it, the court went through and found the various ways that the particular treatment of, in this case, Chinese forced laborers did not meet that basic bare minimum duty of care that an employer is supposed to show towards his employee. Right, so they're listed there, I won't go through them, but this sort of dereliction theory offers another way that Japanese courts helped at least theorize, right, make a theoretical possibility of corporate legal liability. A third, and I think perhaps for me the most interesting form of liability here is to connect what the Japanese government did and what corporate Japan did and link them and say, you know what, you guys are both liable. Now again, these cases have not held the Japanese state liable under sovereign immunity theories, right? The state can do no wrong, essentially. And as I said, they immunize the corporations for as time barred or as falling under these treaties. But still, they said, when we go back and look at history, we saw that corporations made these requests of the government to supply them with labor. The government then responded by passing regulations that, and again, if you go back and look at the record, all of these things, right? The importation of Korean labor and of Chinese labor came from directives passed by the Japanese government, right? And there's very clear regulations that said, what it would take or what to do to bring laborers over here, right? So these cases articulate this theory and say, well, there was this nexus between corporations and the government working together to bring labor over here. And so because of that, we're actually going to hold, again, as a theoretical matter, the idea that both the state and private actors here worked in conjunction, and so both of them are going to be jointly liable. Okay, so one of the, that's not quite ready to go there. There we go. So joint liability is the way to describe that. The other thing I wanted to spend a couple of minutes talking about is this idea of settlement, right? So again, most of these cases, all of these cases went to trial court, appeal court, and up to the Supreme Court. But in a number of cases, even after Japanese corporation had won, and again, as I said, they all end up winning in the end, a number of them actually decided to settle, right? They would offer plaintiffs, a small amount of money, usually in the thousands of dollars, and again, depending on what plaintiffs' lawyers were able to articulate and to extract from the corporations, other things as well. The example I'm talking about came down in 2016 from Mitsubishi Materials, a Japanese corporation, part of the Mitsubishi family. And this was a very slick settlement. They rented out a hotel in Beijing. They got all the media there to take lots of photographs, take lots of videos. There was a tear-filled apology from a spokesman of the Mitsubishi company, and a very profuse and elaborate apology as well. And again, I haven't talked about it much here, but in many of these earlier settlements that took place in the late 90s and early 2000s, Japanese companies were very reluctant to apologize, saying, well, we can't use today's standards, or the government made us do it, or that was then, we're a new company now, what have you. And so for a company like Mitsubishi Materials to actually come forward and give an apology was quite rare. And if you go and look at the settlement text itself, it's a very interesting and culturally sophisticated apology. It has, it cites to Confucius, right? Anytime you want to make good with people from China, cite the Lunyu, cite the Analects, and that goes pretty far. And they said, well, we'll construct public memorials. We'll pay each of the former forced laborers around $15,000. Again, it's symbolic money. No one's saying this approximates the suffering you went through, but again, anytime you have a tragedy like this, the best you can do is provide some amount of symbolic payment. And so that was also included. And they said, look, we're also going to set up a fund, right? And this fund is going to be used for a number of things. We're going to see if there are other forced laborers that have not come forward. Right, so a lot of the time, the forced laborers themselves live in, even now, in poverty in rural China. The earliest plaintiffs here were actually found by Japanese human rights lawyers who sought them out, right, who went to Japan in the mid-1990s with a mission to right some of these wrongs and talk to historians and talk to lawyers and try to get people to come forward and say, yes, we're willing to bring a claim against Mitsubishi or Mitsui or one of these companies that enslaved us during the war and bring a lawsuit, right? So part of this money is going to be used for that. Part of it's going to be used to care for medical expenses. People are all in their 80s, right, or 90s, and as you can imagine, have some serious health problems. Part of it can also be used to educate the children or the grandchildren of forced laborers, right? So this, I think, is a really, as I said, culturally sophisticated attempt to handle a long historical problem. Again, though, there's no recognition of legal liability, and no, even though if you look at the settlement itself, there's talk of human rights violations. it's always done in a passive voice, right? It's never, we committed human rights violations. It's like, there were human rights violations and we are sorry that they happened, right? So it's acknowledging it, but not taking, again, I don't know how, what legal writing is like here in the UK, but the sort of the first lesson you get in the United States in your legal writing classes, you can't use the passive voice, right? And the reason you can't use the passive voice is because the active voice is cleaner and the active voice ascribes blame. I committed a human rights violation, not a human rights violation was committed, right? So you use the active voice because it ties the agent with the action that he or she undertook. So again, one of the models here, this Japanese model of settlement, I think is helpful because it allows for an array of reparations or forms of reparation that are very difficult and rarely seen, even in the transatlantic model I talked about earlier. Okay, so with that, let me turn very briefly to South Korea. Again, during the early part of this millennium, a number of these lawsuits, some of them actually replicated the lawsuits brought in Japan. The people themselves were Korean, they came to Japan to file suits. They lost in Japan, and many of them actually went back to Korea and essentially filed the same suit against the same defendant, and saying, look, don't recognize the Japanese judgment, instead, handle this case, Korean courts, on your own. By and large, Korean courts were, dismissed these cases, saying, look, this happened 50 years ago, 60 years ago. These cases, again, parroting the language and the rationale of the courts in Japan. But in 2012, the Supreme Court of Korea said, yeah, we agree with you. This is a serious human rights violation, and these Japanese corporations should have to pay you for their use of your forced labor, even if it took place 60, 70 years ago. There have been a couple of other decisions, most recently just a few months ago. Specifically, again, the KSC, the Korean Supreme Court, said, well, yes, we understand that there is a treaty that seems to cover all the interests and all of the property rights of Korean citizens, but they said during those negotiations they didn't talk about human rights violations. They didn't talk about, for example, the comfort women. They didn't talk about the issue of forced labor. Right? So for those reasons, we think that you still have an active claim, and so we're going to move forward with that. They also said, look, we understand that these cases had been filed and adjudicated to final adjudication in Japan, and normally that would mean you can't bring the case again here in Korea. There's also an exception to that says if the decision of recognizing the foreign judgment would go against the good morals and social order of Korea, then Korean courts can void it. And that's essentially what the Korean Supreme Court did. They said we void what happened in Japan, we void the decisions from the Japanese Supreme Court, and we are going to allow you to bring this claim here in South Korea. More importantly, these are, to my understanding, the first decisions actually fully recognizing legal liability for World War II conduct. Right? So again, it's pretty incredible that some 60, 70 years after the fact, something that didn't take place in Nuremberg or Tokyo, something that didn't take place in this US litigation I've talked about, or even the Japanese litigation I've talked about, only in South Korea do you now have corporations being, or decisions that attach legal liability to corporations for their role in World War II. Right? So all of which is to say, if at first you don't succeed, try again, and even if that takes, in this case, 70 plus years for you to get your judgment, there's at least some possibility. Now, I don't mean to pretend that these judgments are perfect. We can talk about their flaws in Q&A, but I think from the perspective of either World War II liability or corporate legal liability, they're important precedents in filling what is still a relatively sparse field of judicial decisions that hold corporations legally liable for human rights abuses. Again, these are the different models that I've talked about. I can talk about them more in detail during the Q&A. But let me just throw a couple of conclusions at you, and then we can have, I hope, a spirited discussion about them. Again, 2020, next year, will be the 75th anniversary of World War II. Do I have that right? 575, yeah, okay. So 70th anniversary, I'm sure there'll be tanks and parades and flowery speeches and the rest of it. But I think it's important to note that some of these issues of legal liability, are continuing to be debated and discussed and litigated right now. We've seen different approaches. We've seen the importance of litigation. In each of those approaches, I would submit that in this transatlantic model I talked about, litigation was sort of helpful in bringing the actors, sort of waking people up and making the actors aware of what the issues are, but it really took the political will of the Clinton administration to make those things happen, right? In part, and so that means it's unlikely, I think, that that kind of action will be replicated. On the other hand, we've also seen cases in both Japan and Korea that rely almost exclusively on litigation. I talked about a number of the settlements that took place. We've also seen some of these South Korean judgments, and I should note that as recently as 3 or 4 weeks ago, I saw an article that said that South Korean courts are now seizing assets owned by these Japanese corporations in Korea to pay off these judgments, right? So Mitsubishi and Nippon Steel and these other companies said, well, yes, you've found against us, but we're not going to pay these judgments. And so now these Korean plaintiffs, Yi Chun-shik, a 94-year-old guy, has actually moved to have his judgment enforced. And you see Korean courts now ordering the seizing of Japanese-held assets in Korea to pay these things off. Right? So by crook or by hook, eventually they will be paid. What would it look like for a full resolution of these? Well, that's I suppose, the topic of another talk. But I think based on the research I've done on settlements in other contexts, a full resolution or the full satisfaction of some of these debts would include things like payment, obviously. They'd include an apology, some kind of public memorial, whether that's a museum or a statue or a cenotaph or a stele or whatever it is, and ideally some acknowledgement or admission of liability, preferably, legal liability, because that too has been very rare both in the European and in the Asian context. Okay, I will wrap it up there, and I look forward to any questions or thoughts or comments you guys might have. But thank you for your attention.
Very interesting perspective that I haven't had before, and case I've never heard of before, so it's great to go through that in some detail.
Thank you.
Can I probe you a little bit more about why you say these models are distinct?
I don't say they're distinct necessarily, but press me anyway.
Yeah, so the Japanese model and the transatlantic model, you said the Japanese model was different, it's not distinct.
Yeah.
But isn't it just a difference in maybe form and extent, and maybe the political climate, rather than any different approach to finding a resolution that is, yes, short of your full resolution? I mean, isn't it just a different approach? I mean, the same things are the same. There's a fund that's set up. There is some discussion with a symbolic payment, some award, and a limited recognition that there was an issue that needed to be rectified. But I don't think there's any way different, except playing out in a different climate.
So again, you're right. I think probably the biggest difference is that in the European context, each of those settlements was achieved with the explicit authorization of the government involved. Right, so the German government set up something called the Remembrance Fund. It put I think 5 billion Deutschmarks, and German corporate interests put in another 5 billion Deutschmarks, and then that was distributed to people who were either slave laborers or forced laborers. The settlements I talked about in Japan were strictly private, right? The Japanese government has said nothing. The Japanese government has said, everything has been settled through the treaties. We're not going to pay a cent. We're not going to pay a cent. this has all been resolved 60 or 50 years ago. So in that case, it's quite dramatically different because people like, and I should point out, Abe himself, the current Prime Minister of Japan, is one of the arch sort of denialists in this movement, right? His father himself was one of those, is a convicted war criminal, Kishi Nobusuke. Abe himself is a very ardent nationalist right-winger who thinks all of this stuff is hogwash and has been settled long ago. His current line with regards to the comfort women, something I didn't talk about, but something which I'm prepared to talk about, is that, again, 30 years ago, he would have said, didn't happen, didn't exist. Now, the current line from his party, the Liberal Democratic Party, is that there's no documentary evidence that they were coerced. Right? There's no documentary evidence that they were coerced. Well, A, there's no documentary evidence at all because you burned most of it. And B, and one of the interesting things that these lawsuits have brought about is actually historical archival digging. Right? So people have been inspired or prodded by these lawsuits into going and checking in Japanese libraries, Japanese archives, and many of them have actually brought forth, documents that quite clearly link the Japanese military to these comfort stations, right? So for a long time, as I said, it was, this is all private actors, no government involvement. That lie has been soundly debunked by historical research, and part of that research has been in reaction to these lawsuits as lawyers and historians try to unearth the factual record that led to the comfort women or that led to the forced labor program as well. But yeah, right, I did not make that clear, but there is, the important distinction is that the European governments worked with US government officials to produce those funds and settlements, and that has not been the case. And I don't want to make the Japanese government exclusively the bad guy. I think the South Korean government and the Chinese government, the PRC government, have also been neglectful in not taking these cases up because they're politically sensitive or because they're going to discourage investment. So even though I think Japan is probably the most, or people like Abe are the most vocal in denying claims, I don't think the South Korean government or the Chinese government have been particularly interested in resolving these claims either. Yeah.
Well, first of all, it's super interesting. I've at some point doing the same thing, but I didn't have access, or I don't speak the language. It's so there's no way for me to actually read the court, the trials and everything. So everything I could rely on was the indictment of the new Far East case, the tribunal, and this is super interesting. But I have a question more about what's your agenda doing this research? It's as interesting as all that is. What is?
Why do I do this?
Right.
Yeah.
Why are you promoting this?
Why am I promoting it? Well, I chose this topic about 13 or 14 years ago. At the time, I was working for a firm that was defending one of these cases in California. I joined the firm afterwards, but I made a deal with myself. I said, look, I'll go work at this firm if I write about this issue, from a scholarly perspective when I leave the firm, right? So that was my sort of entree into this world. I thought when I started writing about this in 2005 and 2006 that maybe I get one article out of it or two articles out of it, and then it's 2019 and I'm still writing about it. I've written about other things as well, but it's the gift that keeps me giving, I suppose. Obviously, I'm not personally related or directly related in a meaningful way. But I am someone who's interested in China, and Japan, and Korea, and this is a way to look at this issue and look at how even now these issues, these long I don't want to say forgotten, but long gone historical issues continue to incite anger and passion and protest throughout East Asia. So I think they're still very politically salient even now.
Right. So am I correct to assume that you're there's underlying agenda saying the law can be used for the purpose of resolving the political conflicts, anger?
Yeah, I mean, so there's a whole literature about what litigation can do, and I think litigation obviously is a way of solving a dispute between two parties. But if you think of litigation from a public law litigation, Abe Chase or Transnational Public Law, Harold Coe, view as well. You can understand it as a way to advance agendas, as a way to shine light on historical pasts that people have either not fully grappled with, or in some cases not even fully recovered. Right. So part of this historical record is only now being uncovered. So I think litigation can sometimes play a role in dealing with some aspect of the underlying harm. And I think one of the reasons I spent so much time talking about settlement is because I think you sort of have to have litigation to get someone's attention, to say, look, this is a real issue. And in that sense, litigation can be a cudgel to beat someone over the head with. But I think once you get their attention and they're paying attention and they're willing to have a discussion with you, then it might make some sense to move away from a strict legality and look at how else you can repair an issue. Because at least with regard to Japanese tort law or tort law in general, tort law provides a very brutish set of reparations, right? Essentially money, right, or injunctive relief, and that's usually not what people want. What's interesting about some of the countries I'm talking about, China, Japan, Korea in particular, is that each of them allows an apology as a remedy. Right? In most of these cases, one of the things that plaintiffs request is an apology, right? Saying you've defamed my character, you've hurt my reputation, you've ruined my dignity, and I want you to apologize. Now, unfortunately, I think that's not something that courts have ordered, right? Even though that's within their power, they said, well, these actions were not taken to defame your character, and so therefore you don't qualify for an apology under Japanese law or Korean law or Chinese law, as the case may be. But again, once you get someone's attention through litigation and can walk them through maybe some of these other forms of dispute resolution, then I think you're moving forward towards a resolution of these issues that, as I said, continue to create controversy both politically and also, I think, for many of the victims, continue to create trauma for them as well.
Like two things, just like not really classroom but comments. Interesting for me. One is the labor for conflict women and all those issues. Like, as of today, you would think of them within the human rights region, but then in terms of litigation, settlement is always in a commodity form. Like there's some money, something to be settled. That's like for me, it's just like eventually everything translates into money. And
yes.
Then, of course, as you were saying, there's the apology aspect, which is very interesting. There's a culture dynamic there.
Yes.
Yeah, for me, that's so interesting.
Yeah, and so again, I think we can rightly say, well, law doesn't provide us a particularly sophisticated set of tools, and I think that's right. But there are also things, the UN put out the basic guidelines on remedies for grave human rights abuses in 2005. And that document, among other things, lists a whole variety of forms of what they call satisfaction, right? So maybe it's not money that you're after, but it's actually a historical inquiry, or maybe it's you want the ability to face the people who tormented you, right? Or maybe you want them to apologize publicly, or some other form of remedy. So again, most legal systems, including the United States legal system, may not provide a particularly rich set of remedies, but I think there is, at least at an international level, or at least at a UN guideline level, a richer set of alternatives that may, and I think in this case, are really crying out for a different form of remedy. I don't think these people want $3,000 or $5,000. I think they want official recognition. They don't want to be erased from history, as most of them, as they were from roughly 1945 till, let's just say, 1995. And so they're also trying to reinsert themselves into the fabric of history, having been erased from it for most of the past 60 years or so.
You're going to mention that because most of the people are dying out.
Yes.
They have to, right now.
You can do it now. Right? Yes.
And that's why this project, now.
Yes. Although, depending on the jurisdiction, in many cases, even if the party, him or herself, dies, the heirs, I think just the first generation, the children themselves can also continue to bring claims from their parents, if that's what the child decides he or she wants to do. Yeah. Back.
So if I can ask, this is really fascinating, if I can ask a short clarifying question.
Sure, yeah.
So when you discussed the joint liability between state and corporate actors, was that tort liability or
Yes.
was it?
Yeah, it is tort.
Was there any attempt at an international law argument there, shared responsibility?
Yes.
Under
Yes. So I should point out, in many of these cases, Japanese lawyers brought claims that sounded in international law, right? So they would talk about the Hague Rules of 1899, they would talk about the Slavery Convention, they would talk about the Forced Labor Convention, and I've written another article that deals with that aspect of it. Japanese courts have been very reluctant to handle the international legal aspects of it, as I think judges in the United States would be, and I suspect many judges who don't have training in international law would be. So those cases have been presented to Japanese courts. A couple of them have found violations of the Slavery Convention with regards to the comfort women. One of them found a violation of the Geneva Protocol on the use of chemical weapons from 1926. So there's been, de minimis engagement with international law, not because lawyers haven't tried it or because they haven't, cloaked these claims in international legal theory. But because Japanese judges have been either unwilling or unable to understand these claims under international law rubrics.
So the sort of broader question I'm going to ask, do you know, or has there been attempts to use this kind of language for other, maybe more recent historical or large-scale human rights cases? I'm thinking in particular of, so we have some research going on about supply chains and the use of migrant labour and grey labour. I was wondering just if you've seen, for example, the idea of forced labour as being a thing that you can then sue for kind of later on. Have they tried this with other groups, or has it mainly been focused on this sort of World War II?
Oh, my own research?
Your own research, or just in general, if you're aware of spinning some of these ideas into...
Yeah, I mean, I'm sure there are more contemporaneous things that this applies to. I've seen my own mission as to sort of focus my attention on this, because this stuff is important and is largely open only to people who speak either Chinese, Japanese, or Korean. And my point is, the rest of the world needs to understand this. Whether that can be translated into a case involving supply chains, I mean, that would be great. But I still haven't seen it. But I'm sure people, or I would imagine people who are talking about supply chains would use at least some of the underlying legal theories to advance their claims, whether it's the Forced Labor Convention or other international law instruments to ground their claims in the human rights framework.
Thank you for your presentation. I have a question. When we talk about the corporate liability, so and I know that you must lead a lot of cases from the domestic court and a lot of cases and a lot of compensations. So do you think that the things the decisions from the courts is like the effective compensation? So for example, why don't we think about something else, like for example for the economic compensations, like for the compensations of the people that directly to the affect people in that group. For example, like some law on migrations of that country that may be relevant to the people who may be affected from the World War II. Because if we sue case by individuals, so I think there will be no end because there's a lot of things going on at that time. So this may be not an effective way to sue case by case.
So, yeah, I mean, I don't think it's the best way to resolve issues, but I think if litigation didn't exist, these issues wouldn't come up at all. Right? These issues would have been long forgotten and dismissed from public memory. So you're right. Any individual litigation can only address the narrow harm visited upon one people or 5 plaintiffs or whatever it is. And that, you're right, on the one hand excludes others who may have also been subjected to that. I guess my response to that would be, well, litigation at least offers the possibility of compensating those 5 people, because nothing else I've heard of or am aware of offers that at all. Right? So litigation is by no means a perfect solution. Litigation is, by its very nature, between 2 parties. But I guess the thinking is, or the hope is, and again, we go back to the US example where, again, you have a couple of lawsuits that then catch the attention of government officials who are then willing to bring the case and say, okay, can we have a broader discussion and a broader set of parameters in a foundation or some other part, in Switzerland there was a commission that went back and looked at the role of Swiss banks and how they, disappeared hundreds of thousands of accounts that belonged to Swiss Jews during World War II, right? So I think maybe in the ideal world, litigation spurs government actors to then take on the historical work or the other kind of work that can be done. I guess I would say without litigation, you're never going to get the attention of anybody, right? So as imperfect as litigation may be, it I think can be an effective cudgel to force actors to think in the first place.
I mean, like for example, so in your research, how do you find something like the National Assembly of Japanese government may pass some law that have directly effect to the people from affected from the World War II or something?
That law has not come to pass. The Japanese, again, I give Japanese human rights lawyers a huge amount of credit for bringing this issue forward. The government of Japan and the Diet of Japan are still largely run by Abe's party, the LDP, the Liberal Democratic Party. And you get to get them sort of like Republicans in the United States, maybe they're like Tories here. They're not people who have a particularly soft spot for human rights. So I don't think you're going to get any kind of World War II Reparations Act passed through the Japanese Diet. Now again, maybe this litigation in South Korea, now that we have several decisions finding for forced laborers, maybe that will signal to the Korean government that they have to take this issue up, and they have. The Moon Jae-in, the current prime minister, has taken this issue up with Abe, and Abe has I think, pretty consistently shot him down and said, no, this is a non-issue. This is all been resolved by the 1965 treaty. But again, maybe with each new lawsuit and each new verdict, maybe that can apply additional pressure to those government actors. There was a comfort woman agreement worked out in December 28, 2015 between Korea and Japan that, again, attempted to offer some amount of compensation to Korean comfort women. The problem with that is in working out this secretive agreement, they never actually talked to any comfort women themselves. So again, it's the same, it's not a white man dynamic, right, because they're technically Asian, but the whole idea that we know what's best for the victims without actually talking to people who might have been involved. There's still a few comfort women still around, still existing. Get their buy-in, get their input before you decide that you were going to have a final and complete resolution of the issue, right? So the statement itself, the agreement was purported to be a final and complete reckoning of the issue, but they never actually talked to the people for whom the agreement was supposed to solve these issues, right? So again, a similar dynamic where you have men speaking on behalf of women. Yeah.
Do you think the title of the corporates would have had influence on this issue? I mean, the state-owned enterprises and the multinational enterprises, do they have had influence on this issue? I mean, in your model, I noticed that there is a joint liability model, and you have said that the state has some liability for what the corporates have done. Yeah. But what if the corporates is actually the state-owned enterprises?
Okay. Yeah. So none of the defendants here is a state-owned enterprise, right? They're all privately held Japanese corporations. Yeah. But I think your point raises a really interesting issue. Let me go back to this. So there have been, as the slide suggests, a number of cases that led to settlement, but it's not until 2016 that you get a big splashy one, right? And the reason you have a big splashy one is because you have a big splashy consumer company or consumer products company called Mitsubishi that, again, everyone in this room has heard of, and they're the ones, and again, I don't want to be too cynical because I actually respect Mitsubishi for doing this settlement, but they were smart enough to turn it into an advertisement, right? They're smart enough to say, oh, Chinese consumers, by the way, we're not the bad, war criminal enterprise that we've often we've often been portrayed as. So some of the other settlements were much smaller in scope, were smaller also in terms of what kinds of satisfaction they provided. And I think for a steel company or a mining company that's not producing a good that you and I are going to buy, they don't need the good press, right? So I think in that sense, it is important what kind of company and what kind of product they have, because a company like Mitsubishi that has a lot of name recognition can use this for marketing purposes, right? And here again, I didn't get into detail, I have an article about it. This was for Chinese forced laborers, right? Even though Mitsubishi used tens of thousands of Korean forced laborers, no settlement with Korean forced laborers, right? So again, at least one partial explanation for that is, well, Mitsubishi wants to enter the Chinese market and doesn't really care about the Korean market because there's 1.3 billion possible consumers in China and 40 million or so in South Korea, right? So the nature of the company is, of course, extremely significant, not so much as to whether it's state-owned or privately owned, but I think in terms of what kind of product it sells and what kind of marketing ambitions it has and where it wants to sell its product, that I think is highly significant on whether it's going to settle and the kind of settlement that it produces. Thank you. Yeah.
I'm acquainted myself with the rookie principles which you mentioned early on. And you said that you didn't think that they go far enough.
Yeah.
Is that because you think that they're two businessmen?
Yes.
And
In
also,
a word.
Yeah. Also, you understand it took about 6 years of research.
Yep.
Lots of surveys.
Yep.
Not much response from companies. There was no public consultation. Do you think it needed that?
So are you talking about the Japan, South Korea?
Enjoying the actual rugby principles on behalf of the UN. So do you think that it's flawed in the absence of public consultation?
So I guess I would go back to, so before Ruggie was appointed, there was a guy named David Weisbrot who was doing the exact same thing. David Weisbrot is a professor, maybe you know this, at the University of Minnesota in the US. So he actually had a much more robust set of principles for corporate human rights responsibilities and liabilities that got, frankly, a lot of pushback. Corporations said we're not going to be held legally liable even if we commit rights abuses, right? So that effort was canned. David Weisbrot was essentially fired, or I don't know what the word is, you don't reappoint a special rapporteur, he was let go, what have you. And John Ruggie was then brought on by Kofi Annan, and I don't know this, but I suspect his mandate was to get principles that will pass through the UN system, right? And so, you have the Weisbrot, they're called the draft norms, if you want to look them up, which I think I and others who write about human rights would have been more comfortable with because they actually allow for the possibility of holding corporations legally liable. That, as I said, got some pushback from multinational enterprises, and so again, you get rid of him and bring in somebody else who maybe toes a line closer to what corporations were willing to agree to. Yeah, I still think the Ruggie principles don't go far enough. And I think that may have been his mandate because, again, you had this earlier, more robust set that was shot down. So I can only assume that when Kofi Annan brought on John Ruggie, he said, by the way, the past from roughly 2001 or 2002 to around 2005, 2006, Weisbrot had the same mission as Ruggie and put forward a document that was more robust than Ruggie's and, of course, was shot down. So that's not necessarily helpful either because it doesn't, and the Ruggie principles are not binding either, right? But at least had they used more binding language, there's a possibility over time that they would harden into a legal liability principle for corporations.
No, I just wanted to know your opinion because there are many scholars who argue that actually the whole point of not speaking about obligations but rather duties towards from corporations is based on the idea that the state is the one who has a major obligation to protect human rights also from third-party interferences. Right. Therefore, by beating the bushes around corporate liability on human rights, and not corporate liability but human rights obligations of corporations in human rights, we are obscuring the fact that it's the state who is not complying with its obligations towards the individuals.
I can see that argument, And there were cases, as you know, as the case was here, where states and corporations work together, conspire essentially to violate human rights norms. I think, you have to look at the capacity of the state you're talking about. There are states, many states, that are far less resourced to ensure and guarantee human rights than many countries are. But even if we're talking about, rich countries and rich states, I still think, even if legally and traditionally the responsibilities have fallen on states, I think by virtue of the resources and by virtue of the imbalance between, in this case, employees and employers, you have to at least begin discussing legal liability for corporations. My personal opinion, I've been wrong before, but I think, again, because of that the power differential, and because, as we know, there are lots of corporations more powerful than many states, you have to go not only where the money is, but you also have to go where the power is. And the power, again, seems to me to be centering in the Googles and the Facebooks of the world, and not necessarily in small states that don't have the capacity to enforce human rights that are being ascribed to them. Yeah.
Do you ever see an effort for people bringing these sort of stories or claims to try to frame the request for the apology in contemporary terms? So like, what happened in the 40s has structural long-term consequences that still continue? And a second, so that's one side.
Yeah.
The other question is, have there ever been efforts to go for a large amount of money with reparations? Like a type of reparations type claim that would be a much more significant amount?
So again, the apologies, I think there are usually, when people file these claims, they'll actually write out what they want the Japanese corporation. They'll specify which newspapers and what they want the apology to say. And even if they don't necessarily spell out how these continue to have ramifications in the modern era, some of the lawsuits have actually done that, right? So in there's been a couple of cases I talked about involving comfort women, and one of the first decisions actually found in favor of 3 Korean comfort women, and said what you're saying right now, that this was, obviously this was a harm back then in the 1940s, 1930s, but the failure of the Japanese diet to do anything about it now is a continuation of that. Right? So that, even though it didn't appear in the apology per se, that was part of one of these decisions from the Yamaguchi District Court in Japan. So I think there is, and of course scholars have also talked about this, that the failure to address this is a continual harm that's practiced upon, whether it's forced laborers or comfort women or what have you. So that is still, I think, part of the discussion. In terms of the amounts, I mean, I think in the back of my mind, I'm an American, and these verdicts are sort of laughably small, because John and I grew up in the U.S., and if it's not a $10 million verdict, then no one's going to talk about it. But John, as you're aware, in most countries around the world, $10 million verdicts are never heard of, right, or impossible, right? So when you tie things, and that's because you don't have uninformed juries deciding who's going to get, how much money. So even though. And also because I think they have to submit a claim that's based on some tangible number, and so no one, as far as I know, has asked for $1 billion or for $100 million, because again, for reasons we talked about with regards to your question, they have to individuate the harm, right? Litigation itself is about individual harm, but at least in the context we're discussing here, you're not asking for a bill to be passed by the Diet that's going to handle this in a comprehensive way. What you're doing is saying, will a court, apply a remedy to these particular facts, to these particular plaintiffs, and that's, at least as far as the cases I've looked at, that's been the sort of ballpark for what these people have been asking for in terms of monetary damages.
I want to play devil's advocate.
Good.
I mean, it's a very nice topic. Sure, corporations are bad. They've always been to make money out of poor people. Yeah, sure.
Okay.
honestly, I do find it very interesting, it's fantastic and everything, but isn't it the idea that after war we have different types of justice and not all of them are formal, because mainly what we're trying to do is achieve reconciliation between different parties so that you can again have a sense of cohesion. That's why sometimes informal justice might as well do the trick, and so on and so forth. And the other thing is that if it's not the money, I mean, if they're not going to get compensations of this sort, if it's just the apology, then isn't that then causing, I don't know, social turbulence or re-invoking bad memories of a very dark time of human history? And that was also sort of part of the political claim behind the ICJ decision on Germany versus Italy, is sort of like, don't open the Pandora's box again, sort of let it be.
Yeah.
And okay, yeah, sure, liability, they're private companies, but then again, I'm not so familiar with how things were working at this part of the world, but for example, companies in Germany that have been, their reputation is bad and how they worked with Hitler and so on and so forth, they were working for the government at that point. So they're sort of covered in, they might be more powerful, they might be more rich. In some countries they might be honestly more powerful than governments, but then again they're still perceived as part of that country. So if the country within it, like through its government and its political sort of process and with other countries, have already reached a deal, then shouldn't we just drop it?
Yeah, yeah. I think that is a response to this. I think I'd push back and say, well, first of all, if you don't acknowledge the facts in the first place, then you're actually, consigning a huge part of human history to oblivion, and that's actually a very dangerous thing to do.
Is that a job for a court, or is that a job for a historian?
I would say it's a job for both. I think the historical aspect of it is very important, and as I said, a lot of these lawsuits have actually pushed researchers and lawyers and archivists to go and actually comb through the record. So I think that historical work is important. But I think there's a second lesson here, which is, yeah, it's important to look at it historically, but you also need to understand it legally, right? Because if you say, well, one of the things I think is really important about these Japanese cases is that they go and they look at these historical acts, mobilizing Koreans or going to China, taking over a village, narrowly bringing the Japanese military together and like they call it rabbit hunting, capturing anybody who flees and enslaving them. And I think applying legal concepts that not only enriches our understanding of history, but also enriches our understanding of law, right? Because now we know what a violation of the Slavery Convention looks like, or now we know what a violation of the Hague Convention looks like. So these conventions exist, and people don't always think that they actually have a material effect in the world. But what I think these lawsuits do is say, yes, even during the 1940s, or even though we're looking at this from 1990s or 2000, 2010, when we go back and look at this history from a legal perspective, we can see that there was a violation here and a violation there. And that had not been done before. No one had actually gone through and thought, well, a lot of this stuff actually does violate basic human rights, and not just from a post-war UN perspective, but from conventions that were actually in effect at that time. Right? So I think that's also an important lesson, that the sort of legal ramifications of this haven't really been explored, and these lawsuits are one way to explore that. Not simply as historical matters, but also that what happened didn't just violate Japanese law, but violated applicable international law at the time as well. I think without these lawsuits, you wouldn't have that kind of reflection as well. Yeah, but I take your point.
So thank you everyone for being here, and thank you again, Tim, and we'll keep it going after.
Yeah, sounds great.
Thank you.